Thank you. Are there any motions from attorneys or parties present?
No, Your Honor.
No, Your Honor.
At this time, then, we will take up the oral argument scheduled for this morning. CR 2566, Aaron Spencer versus State of Arkansas from Lonoke County Circuit Court. And I acknowledge the petitioner's attorney to come forward. Ms. Casanelli. And you've reserved 10 minutes for rebuttal, is that correct?
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, counsel, I'm Erin Casanelli, and I, along with Michael Kaiser, represent Aaron Spencer, who's the petitioner before this court and the defendant in the court below. We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The law requires a careful analysis and a balancing of important constitutional interests when imposing a gag order. The law requires further a very narrowly tailored order that is specific to the case, the interests in the case, and the interests of the public in receiving speech and the parties in providing speech. This court, federal courts, the criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. In this particular case, this gag order is very important. This is an unusual case. I don't know how much factual information has been conveyed to this court, but it's unusual in several respects. Aaron Spencer is a father and a husband. His daughter was assaulted, sexually assaulted, severely, by a man named Michael Fossler. Michael Fossler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So, counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir, and thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fossler's criminal proceeding, and that's important in additional respects. There is no public record of his appearance that I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question. We live stream our court proceedings, and this is a public hearing. So, and it's live streamed. It's also saved on our website. Is that violating the current gag order?
That is an excellent question, and also on my list of things to discuss before this court. This gag order is so overbroad that I don't know that I can answer that question precisely. My belief is that this court has asked for this argument, and I cannot fulfill my duty to this court without explaining the facts and the law that apply to it. But the way the gag order is written, none of you could speak about the case from the bench here. The governor herself couldn't speak about the case if she wanted to. No public official could speak about the case.
Counsel, in preparation for the argument, all of the court has 2 law clerks on staff, 2 attorneys. Were we in violation of the order when we were discussing it with our law clerks in preparation over the last few weeks?
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination. I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion that pertains to it. So I suppose arguably you could be. That seems outrageous.
So even if you assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him, and he can raise it presumptively as to counsel. But as to anybody else covered by this order, what standing do you have?
Yes, sir. There are several things that sort of fall into that category, but as a general matter, the overbreadth doctrine allows courts to consider First Amendment restraints that affect third parties. So I think that's discussed in the Murphy-Brown case, which cites a couple of Supreme Court cases for that point.
But for overbreadth to apply as a general matter, you have to first allege that this can be constitutionally applied to you. The reason why we conduct the overbreadth analysis is because it's constitutional as applied to you, but it's unconstitutional theoretically as applied to others. Here, your argument is it's not constitutional as applied to you, so I'm a little bit confused how we get to overbreadth.
Well, either way, I think it's unconstitutional as applied to my client, in part because it's overbroad and it encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases
Are there cases that treat overbreadth that way? I mean, I'm not familiar with any Supreme Court
No,
cases.
that's a bit of a different doctrine. So think of all of the cases most of the cases that are out there involve the press, right? The press is coming forward and saying, you know, we oppose this gag order that you have imposed that prevents all the parties from speaking. And the press is the recipient of that speech, and most often the defendant doesn't want the speech. But the press is still allowed to bring that motion. At times the parties bring the motion, but they are addressing whether they can speak and whether speech can be provided, for instance, in public records.
Then I guess my question is, if we found the gag order is unconstitutional to you, your client, is that sufficient, or are you seeking more relief, and that's why you've argued overbreadth? Because normally, if we said it was unconstitutional as applied to you, the analysis would stop. There's a stack of First Amendment cases that say that. The analysis stops. Would you be satisfied with that relief, or are you seeking to invalidate the entire gag order? And again, what's the standing for that?
I don't think that the court has to go that far, because I think that it's unconstitutional as to Aaron Spencer, and that would cover all of the concerns, because there's really not a part of this order that is sufficiently clear, that indicates a substantial compelling interest, that's narrowly tailored. So I think that if the court decides that the order itself does not comply with constitutional mandates, then that is sufficient to get to the end, which is that it needs to be submitted back to the circuit court for a proper analysis.
So a slightly different variation of this question then. What I took some of your arguments to be framed as, yes, they were sometimes framed in terms of overbreadth. I thought maybe you were making a facial challenge as to the gag order itself and just arguing it's unconstitutional in all of its applications. Am I wrong about that? Or?
That's a tough question for me to answer. I believe that it is facially unconstitutional, but I don't think the court has to reach that point. I think for purposes of our argument, pointing out the circuit court's disregard for the rights of the people that it encompassed in the order, and for the overbroad.
But that sounds like a facial challenge, right? That when you start talking about other people, if it's an overbreadth challenge and we decide that it's unconstitutional as to you, the analysis stops. So you've either got to say it's a facial challenge or it's not really an overbreadth challenge at that point. So which is it if you're talking about other people?
Well, the point that I'm trying to make is I think that is important evidence of the order's overbreadth and the problem with the circuit court's lack of analysis. I think that
Counsel, what I thought I heard you say earlier was that it wasn't just that you're arguing that prohibiting the defendant's speech, it was his receiving speech as well. And is that why it in a sense, you're arguing it's unconstitutional, the restrictions on others is because it prevents them from him receiving their speech?
Your Honor, thank you, Justice Wood. My point there was just that the First Amendment protections are both as to recipient and speaker. In this instance, our position is that Aaron Spencer, the attorneys, the people that represent him, his family, any interested party should both be able to speak and have access to the information necessary to speak. So, for instance, closing all court records. And by the way, there were no court records made public. So even the affidavit of arrest or the charging document aren't public. But he has a right to access those records and share them with other people. That is speech.
That seems to be slicing it, I mean, putting too much emphasis on one point. I mean, courts seal records all the time for various reasons. Now, maybe you don't think there's sufficient justification here. There, as far as I can tell, there really are no fact findings here. So maybe it's not warranted here, but there's not some abstract right. I mean, I don't think you can identify a case, can you, where the courts have recognized an abstract right to access information that says courts can't seal their records.
I'm sorry, Your Honor. I believe that the right to a public trial includes the right of public access to court records.
Does it include the right to release evidence that you obtain in discovery, then, in your view?
No, I think discovery is treated differently. Discovery is regulated under court rules. I'm, as an attorney, prevented from disseminating discovery material. There's no need for a gag order in that respect. The court rules cover that. So I think the case law also suggests that discovery, the United States Supreme Court has addressed that discovery is a separate and protected class. I'm dealing only with the public record aspect, and I agree with you that absolutely the court can seal records after the appropriate analysis has been undertaken that shows a need to do so. In this instance, we have sealed every public record. In fact, I noticed that since we filed the final brief in this case, the circuit court clerk has added some notations to the electronic docket online. But while we were doing briefing, you couldn't even see the title of documents that were filed. There's no record of my client's entry of a not guilty plea. The public was prevented.
Read correctly at some point that the arraignment was actually sealed?
The arraignment, the court would not allow community members in the arraignment. I raised an objection. It was not well taken. And so they were not allowed in the courtroom.
So no members of the public, no members of the press allowed at the arraignment?
I can't swear to that because my back was to them, but I watched the bailiff and heard him tell numerous members of the public that the court had ordered that only 2 members of the defendant's family and I believe 2 members of the victim's family would be permitted in. Whether or not he ultimately let somebody slide in, I cannot attest to that, but he turned away a line of people, and it wasn't 100 people, it was about 8 or 10, and he turned them all away.
But counsel, we haven't even, are you raising a right to public trial? Because we haven't, extended that beyond voir dire. We haven't extended that to arraignment and further.
No, Your Honor, I'm not, but it is an important consideration here because Aaron Spencer may not have taken so much issue with this gag order if it didn't seem like this entire proceeding and the entire proceeding of Michael Fossler were being conducted in secret. And the public, members of Lonoke County, have a great interest in knowing how this happened and knowing why its public officials are making the decisions that they are.
Ms. Casanelli, you said something a minute ago that made me think that the remedy you're seeking here is for this court to remand or send this back to Lonoke County Circuit Court to have a hearing. Is that what you're asking for?
I'm asking this court to vacate the gag order and to provide the court and all courts in Arkansas with some kind of analysis, some kind of careful balancing, some direction, and order the circuit court and all circuit courts to conduct such analysis before they impose a gag order to ensure that it is appropriately narrowly tailored only as is necessary to prevent substantial prejudice. That's what I'm asking for. And in this instance, the circuit court undertook no analysis, took no evidence. So there is nothing on which a tailored gag order could be created and imposed.
So the standard you just articulated, which case does that come from? I know that the cases say various things at various times. It's a little bit unclear what the U.S. Supreme Court has told us the standard is here. Where are you getting your standard from what is the closest match, and is it the same standard applied to everybody that this gag order applies to, or is it just the standard that applies to you and your client?
So I would submit to you that the standard doesn't matter. Under any of the standards that have been laid forth by the Supreme Court, this gag order fails. I could talk all day long about whether Gentile sets a standard or Nebraska Press should be used, but I don't think my evaluation is that there is not a rigid test. I think the Supreme Court has said repeatedly, like the clear and present danger is not a formula. It is an indication of the careful balancing that should be done to ensure that a gag order is addressed only to a substantial and compelling public interest.
The balancing language, where does that come from? I'm not familiar with a case that says balance.
Nearly every U.S. Supreme Court case talks about the weighing or the balancing.
But does it actually apply a balancing test as one would traditionally think of it, or does it just say we balance in formulating the standard, we balance the interest? Or is it a pure balancing test?
It is not a pure balancing test. The court has been clear that it's unique to every case, but that it has to have the hallmarks of applying the heavy presumption of unconstitutionality as to a prior restraint, such as a gag order.
And in response to Justice Hudson's question, you were asked, what are you seeking here? Are you just seeking sending it back for hearing? And you said you'd like guidance, but what I just heard from you is an amorphous test that doesn't really provide that. I mean,
unfortunately, the United States Supreme Court hasn't addressed this situation because most often it's a defendant's assertion of a right to a fair trial that was not honored because of change of venue, or it's a press case. So I think we're looking to this court to help us in the state, to help us combine those cases and come up with what is the proper direction. But I do not mean to insinuate or indicate at all that there is a rigid balancing, because I think that the constitutional rights at issue don't allow for that. It's going to be different.
Do I take from your answer then that you think the standard varies depending on whether the state has asked for it versus you've asked for it?
No, I do not think the standard varies. I think that the circumstances of the case are necessarily going to make, for instance, the state's compelling interest in a fair trial is going to have a different weight under the circumstances of each different case, as will the need to narrowly tailor the order. It necessarily has to be specific to the case, but we could use some real guidance as to what courts have to do to evaluate those issues.
Your time has expired. You can continue into your rebuttal, or
Thank you.
thank you. And the attorney for respondent.
Thank you. Madam Chief Justice, and may it please the Court, I'm Assistant Attorney General Joseph Carl Lupke, here today on behalf of the respondent, the State of Arkansas. The Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. Reviewing this order and Spencer's claims under the intermediate scrutiny standard set out in Gentile v. State Bar of Nevada.
Counselor, what would be the harm in sending this back to Circuit Court for an evidentiary hearing?
I think the harm is that there is sufficient evidence in the record to support the order here. It is undisputed. They didn't dispute it below. They haven't disputed it here, that there was sufficient media attention, expansive media attention, that supports the idea that there is a substantial likelihood of material prejudice based on statements from trial participants. And then the other thing you have is the statement that was attached to the state's order, which represented an effort on the part of the defendants and his attorneys to try this case in the press. And when you have a clear attempt to try the case in the court of public opinion rather than the courtroom, then it is appropriate to prevent.
Wasn't there just one statement here? I mean, you only attached, I think, one statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement that the defendant says was in response to something that the prosecutor had said cryptically. Like, that seems like a bit of a jump, doesn't it?
There is only the one statement in the record. That's correct, Justice Browning. But I think when you read that statement, you can see the intent behind it. And the fact that it was in response, or may have been in response to statements made from the state, those statements aren't in the record, the fact that the state may or may not have made statements only further supports the need for the gag order. The fact that both sides are talking means that a gag order is appropriate. And when you read the substance of the statement, it contains a style of argument that wouldn't be allowed in court. It has evidence as to the character of the accused and the character of the victim that may or may not be admissible. And so this court, the circuit court, needed to ensure that the case is decided based on the evidence that comes from the witness stand, and that's what the gag order does.
But you jump from one point to the other. I guess where I'm confused is I'm not aware of a case that says you have a right to, the state or anybody else, a right to a trial without any publicity, which almost seems like what happened here. The circuit court decided there should not be any publicity. Instead, your right is to an impartial jury,
That's
right?
correct.
And why wouldn't things like voir dire be sufficient for dealing with that? I didn't see any findings to that effect here.
One, I think because voir dire was raised in the defendant's briefing below, it's implicit that it was rejected by the circuit court. I think you can find an implicit finding there. And I think what the Shepard versus Maxwell case says, and what Gentile itself says, is that when we're looking at ensuring a fair trial, the court has to act prospectively to prevent prejudice before it happens.
Counselor, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quick, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask you, how quickly do you read?
As quickly as I can, Your Honor.
If you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing, but all we have in the limited record before this court is the file stamps. And the file stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know for sure whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court, and it had the opportunity to consider it, so I think we can find an implicit
Counsel,
finding here.
let me ask you another question. When you're talking about discretion, and I think that's what Justice Womack's getting to, you said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020 in the Arkansas Democrat Gazette case when they brought a writ of cert to this court. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level. And so that's my question is why would we treat it any different than the case we vacated in 2020?
I think you're dealing with who's making the petitioner here. The petition is the defendant and not the press, and we treat press cases differently than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored, I would compare
But
the
we
categories.
vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends, judicial officers. It was same language.
I'm not aware of that case, so I can't speak to that, and I apologize for that. But what I would ask this court to do is compare the restrictions here with the restrictions that were present in the rule in Gentile, and they are very similar. The rule in Gentile is found in the appendix to one of the opinions, and that was found to be narrowly tailored for First Amendment purposes. And so I think that this order
For purposes of the defendant's counsel, perhaps, but one, it wasn't a prior restraint, right, in Gentile, so that's different, and that was a case about defendant's counsel. Here, I think you concede, correct, that this order goes beyond defendant's counsel and applies to the defendant. Why doesn't that make a difference? Where do you get from Gentile that standard applies to others?
I think two things in response to that, Your Honor. In terms of why it would apply to the defendant and other parties, Gentile, while it did specifically address lawyers, some of its language said, because lawyers have special access to information through discovery, client communications, extrajudicial statements, their statements are likely to be received as authoritative. All the parties here that are restrained are in the same boat. A statement from the defendant is likely to be received as authoritative because he knows what happened. And so the same justification that applies to lawyers would apply to him. I would also say that while Gentile dealt with a subsequent punishment, the bar rule at issue there was a prior restraint on the attorney's speech. It was a rule that existed that restrained the attorney's speech. He was then subsequently punished. But I think it can be viewed as a prior restraint case.
That one, you could make the argument in Gentile that was people directly connected. There is language to that effect. But here we have an order that applies to any public official now holding office.
Yeah, and my first response to that, Your Honor, would be that those claims aren't in front of this court. The defendant doesn't have standing to raise them. And then secondly, while I say that public officials may be broad and probably could be reformed, the idea that some public officials, like the sheriff who investigated the case, court clerk, other people who might have knowledge and were specifically directed, I think would fall into the same category as attorneys, defendants.
So answer the question that was raised earlier by one of the other justices. We're public officials. We all have clerks and administrative assistants. This morning I sat in my office and discussed this case with the 3 people that work for me. And we talked about the evidence and we talked about the issues involved. Did I violate Judge Elmore's gag order?
No.
Why not?
Your
Because
discussion,
it says any public official now holding office.
Because the restraints in the gag order are for public dissemination. Your discussions in your chamber are private. And in fact, they're exempted from FOIA. You have a right in crafting opinions.
Facebook post by the Lieutenant Governor. Covered, not covered by this gag order.
Arguably covered by this gag order, and I think the state would concede that that's probably inappropriate. She doesn't have any special knowledge.
When you say inappropriate, do you mean unconstitutional?
I don't know that it's necessarily unconstitutional, but I don't think it was. I don't think that claim is before this court.
So your boss is the Attorney General. Every legislative session, the Attorney General has a package of bills. Let's say he wants to go to the legislature and ask for a bill that addresses this very situation. He wants to add an affirmative defense to the statute in this type of scenario and has to give the reason why he wants to do that, so he lays out the facts of this case.
I mean, we're party litigants to this case. I'm responding and
Okay, so
representing
let's say
this
it's the
court.
governor's package.
I think the
Did
governor.
the governor violate Judge Elmore's gag order in doing that?
I think the term public officials is probably, if the public officials claim were before this court, the general proposition of public officials is probably too broad and should be reformed.
So what about family?
I
Whose
think-
family? Is that spouse and kids? Is that the 4th cousin you met once at a family reunion 30 years ago that's talking about it at the coffee shop?
And I think that is part of the problem with the general term family, and it's the limits of the English language that perhaps that was not something the state requested. That's something the circuit court did on its own. I do think it is appropriate to restrain certain family members for the reasons I said. Spencer can't filter his speech through his wife or his mother or people that they would see as authoritative. But I think it would be appropriate.
Then are you reading in the provision that talks about release, to Justice Womack's question, release any purported extrajudicial statement? Are you reading that as a limitation into the family language? Or I guess I'm a little confused as to the position.
I'm sorry, could you repeat that?
So the first, here is basically you can't launder the statement provision. Any purported extrajudicial statement of the defendant. Are you reading that limitation into the family provision, or?
I think the order says that the family is a restrained party and that is a restrained speech, so I think that would apply. I think that's a fair reading of the
So
order.
counsel, if defendant planned to call his daughter to testify, he couldn't publicly announce that, correct?
No, under the terms of the gag order, the identity of witnesses are protected.
But-
I think
Then why is that necessary if you can publicly say the arresting, investigating officers and agencies are public, and they're going to be necessarily witnesses? So why can the defendant not release his witnesses, but obviously the state can publicly name some of their witnesses?
I think that, first, I think that the defendant's daughter could be a witness either for the state or for the defendant, same as the investigating officers could be witnesses for either. And I just think that the terms of the order says that you're allowed to identify the arresting officers, but you're not allowed to release witness lists, and that's to try to ensure a fair trial by preventing witness.
A fair trial for who?
A fair trial for the public and a fair trial for Mr. Spencer. It's a fair trial for all parties involved and for the people of this state.
Can I ask about the overbreath thing? Because I'm not sure that I got a clear answer from opposing counsel about whether they're raising an overbreath challenge, but it's certainly in their brief. What is your view of how we would conduct that inquiry? Because normally you have a statute, it's very clear, there's one standard that would apply across the board. It might be unconstitutional, or it might be constitutional as to a particular person before the court, unconstitutional as to others. Here, assume for a second with me that the court has set different standards for different people, or certainly different articulations of the standard for different people. So what do I do on the front end to determine whether or not there's substantial overbreath? Do I have to go through every group in the order and apply a different standard and say, well, it's okay here, it's not okay there, so I add them all up and somehow it's substantially overbroad? Or how do I do that in the state's view?
I'm not sure I can answer that question, and I think your question demonstrates why an overbreath challenge isn't appropriate here and wasn't raised here. They're raising separate challenges as it is to his speech, as it is to the other speech. They're raising a bunch of different as-applied challenges. They don't have standing to assert it on behalf of those other parties, and that's the problem. And I think that there is a possibility that different standards could apply to different parties, which wouldn't lend itself to an overbreath challenge.
And then-
the general public, sorry.
On that standard, then, I guess, what is your view of what Gentile says and what Nebraska Press says, and what is the difference between those two standards?
Nebraska Press is they deal
with different people, I'll give you that, but other than that, what is the difference in the articulation of the standard?
I think not only do they deal with different people, they deal with different First Amendment rights. One is dealing with free press and one is dealing with free speech, and those are different delineated rights in the Constitution. I think that open press, they talk about there being open discussion in this case in the public. We view that with much greater scrutiny in the law, whereas the trial participants, what Gentile has said, what Shepard has said, and what Nebraska Press has said, are viewed under a much lesser standard because it gives the court room to balance a fair trial versus those First Amendment rights.
So why does the different standard matter here? Because as I understood your articulation of the interest here, I think your view would be that you survive strict scrutiny. So, what is the relevant difference in the standards here? Because you started by saying this is intermediate scrutiny, so you obviously care about the standard. I guess I'm trying to figure out why does that matter here then?
Well, it matters here because not only are we trying to ensure a just result in this case, but we're setting the standard going forward and for future cases. That's what this court does. And I think it matters specifically where intermediate scrutiny versus strict scrutiny matters in this case is when it comes to what narrowly tailored means, and specifically the consideration of least restrictive means. Under intermediate scrutiny, this court does not have to, or the circuit court did not have to choose the least restrictive means of choosing its goal.
That's generally true, but doesn't some of the language in Gentile indicate that maybe this is like intermediate scrutiny with a bite almost?
No, I didn't read it that way at all, Your Honor. I think the language specifically said that the court doesn't have to rely on things like voir dire and a change of venue because Those will come after the damage is done. We don't know and cannot know, that as Nebraska Press, the known and unknowable, whether or not they will be sufficient to do the job. And given the primary constitutional duty of the court is to ensure a fair trial, it's important that they act prospectively.
Your primary interest then is in avoiding tainting the jury pool? That's the state's interest here, or is there another interest?
Yeah, well, I think it's in ensuring a fair trial, which involves tainting the jury pool and protecting the witnesses from harassment. I think there's twofold. I think if you read the restriction in the order about the identity of witnesses, that would go towards protecting witnesses.
So what about then the restrictions on making statements about a witness's testimony after the witness has already testified? What purpose does that possibly serve with respect to either the jury pool or intimidating witnesses?
I think it depends upon whether those statements are made in a pretrial hearing or in a trial. I could see and concede that when the jury has already been seated, that there wouldn't be reasons to restrict statements anymore to the press as long as the jury is sufficiently sequestered or sufficiently instructed not to read press accounts.
It feels as if the discussions that you're having with my colleague are having well-reasoned discussions about where this perhaps could have been limited more, tailored more, and that would have been the benefit of having a hearing in front of the trial court, where the trial court could have had these discussions about what really the harms were out there, what you were trying to prevent, and that would have happened rather than sort of whether it happened in a day or 6 minutes, a quick form response.
I think the circuit court had all the information it needed in front of it to craft the order that it did, and I think that order is narrowly tailored. It specifically targets public dissemination of the evidence in this case, and just that, and that's to prevent
and the fatal flaw with that is that we vacated a virtually identical order in 2020.
And I think that Gentile would say that
Well, it
this.
doesn't really matter, does it? That's U.S. We're saying an Arkansas case.
I think when we're applying the First Amendment, what the United States Supreme Court says matters.
Well, I would disagree when they've raised an Arkansas constitutional right here.
And I don't know that
We can give more protections, correct?
We can give more protections. They did not develop an Arkansas constitutional argument. I don't think, while they did cite it, they did not develop it. They
It's hard
purely
to do
relied.
without a hearing, isn't it?
I
develop
think they
that
could have
argument.
developed it in their briefing. They had a full briefing schedule. This court requested additional briefing.
But would it matter if that prior order from this court was a syllabus entry instead of a reasoned opinion?
I think it does make a difference, because I think the important thing today, and what I would say in closing, is we want to adopt a good standard moving forward. It's important to ensure that justice is done in this case, but this court's opinions matter going forward. And so I would ask this court to adopt the Gentile standard, because it gives the court room.
Counselor, I know you said you were closing, but I have a question for you. On the last page of the order, right above the judge's signature, it says the entire case is now sealed. What does that mean?
It means that the public docket and the docket entries are no longer public. That's what I took it to mean.
That's what you took it to mean? Do we know what that means? Does that mean that we're not going to let the public into the various hearings and portions of the trial that happen going forward? Do we have any extrapolation somewhere else in another document from the judge to kind of expound on, what she meant when she said the case is now sealed, the entire case is now sealed?
No, the only thing I'm aware of is the order before this court. And I think when we talk about sealing, I took that to mean sealing of the record. The defendant has a right to a fair public trial, and I have no reason to believe that that's not going to happen. I'm out of time. I would ask this court to deny the petition for writ of certiorari. Thank you.
Counselor, as it applies to the other party, the non-parties and the non-participants. So essentially, the family members and let me make sure I get the precise language, any public official now holding office, as it applies to them. By having a gag order on them, is there any prejudicial impact on your client's rights to a fair trial or your client's constitutional rights otherwise? And if so, what is that prejudicial impact?
I would say there is a prejudicial impact. Each case that I believe in state court and in federal court that's evaluated gag orders in a similar way has addressed the scope of coverage as to third parties or groups of covered third parties. I should have made that more clear earlier, whether or not it was specific as to a very precise prejudicial effect on the defendant. However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lonoke County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both as a citizen and as a criminal defendant. And I think every case that's analyzed this has, without real discussion, evaluated the scope as it applies to other people, as well as the scope of its application to different types of speech and other matters. So I think that that's a proper consideration, and it also, as I said before, contributes to the court's finding that the order is not narrowly tailored.
The cases that you're referring to that do that, they generally do that either because it's a press case or because it's an overbreath. So take Murphy Brown, for instance. Judge Wilkinson's opinion basically just says, we're applying overbreath analysis, never does sort of a preliminary determination of how that would work. So the same question that I asked the state, how do I conduct that analysis? Do I have to do some different test application? Assume with me for a second that I disagreed that strict scrutiny automatically applies to all of it. If I have to do that, how do I do that analysis, sort of the preliminary front-end analysis? Or wouldn't it have been easier to frame it as a facial challenge?
I think you can tell that I think that's a tough question. I think that there are different standards that apply, and unfortunately here none was applied. So any standard would be better than no standard, but I think the court does have to consider what burden must be met to prevent non-parties from speaking. I don't disagree with the state that trial participants can be restrained in ways that are more substantial than third parties, people who are not within the proceeding. I can't legitimately dispute that. But the cases, Nebraska Press, Shepard, they don't articulate for lower courts how to do that. No Supreme Court case does, which is why we're having this discussion and why there's not a defined answer to it. But I think the circuit court has a duty to take care to address those categories of persons in specific ways, because those rights are different and they are to be evaluated differently. I want to be sure to state to the court, there is no case that applies intermediate scrutiny to gag orders to this circumstance. There just isn't. There's no case that dispenses with the least restrictive means analysis. Gentile does not do that. In that case, it was a subsequent punishment at issue, not a prior restraint. That cannot be reasonably disputed. The Supreme Court has told us that those things are viewed differently and prior restraints are...
It says that, but when have they ever actually indicated how the standard is different? I mean, I recognize you're entirely right. The court has said prior restraints are treated differently. Tradition in this country, we treat them differently. But when it comes to actually analyzing them, can you point to the delta in the way that the court has treated them differently?
Yes, I think the court historically has consistently held that prior restraints are what they call freezing speech as opposed to chilling it. Because when you speak in the face of a rule that tells you, of an ethical rule, you are aware of the danger in doing so. It's very different.
I agree with you in those general terms, the court has said that, but where has it applied a different standard?
I don't know that that's specifically come before any court. I mean, I cannot think of a case where that has been specifically addressed. In my mind, that is something that is stated repeatedly. The evaluations of rules, like the ethical rule in Gentile, have been evaluated slightly differently. I would say this as it pertains to Gentile in this analysis, that because it was a regulatory rule, the court was looking at the systemic issues. So the court was looking, they didn't dispense with the least restrictive means. They didn't have a case to apply that analysis to. So in that instance, they're looking at a rule. Is this necessary in a profession that we as a state license? Can we impose this ethical responsibility? And how does that rule affect sort of the systemic costs that may be associated with it? In a case in a trial court, I mean, we don't hear circuit courts say, well, you know what, we're not going to do extensive voir dire because it's too expensive. You know, we're not going to change venue even though maybe a defendant's entitled to it because it would just be too much of a cost on the system. I mean, Gentile is obviously dealing with the overall systemic assessment, but within the First Amendment analysis.
Well, counsel, I think what the state was saying is that they thought that perhaps some of what you said in a statement, you could not have said in court. Would you agree with that?
I'm sorry, I could not have said.
You could not have said in the court. You could have not made some of those statements.
Well, I have sort of agree and disagree.
Okay. Well, and so I guess following that is that once you did that, was there a legitimate concern by the court that maybe you were going to keep going further, and then that justified the court issuing some sort of gag order, if maybe not this far, against at least counsel?
I think the court, and I think the Trump court talks about this in that opinion, that context is important, and that has been completely ignored by the state in its briefing before this court. That statement was made before arraignment, before there was any proceeding. It is a criticism of a public official. It doesn't include any information that is prejudicial or would be inadmissible. The character of my client will be at issue because he is of outstanding character, and there's nothing that's going to impact that. Michael Fossler's rapes of Mr. Spencer's child are public record. It is a part of this case. And that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point. The very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also when a prosecutor made a comment on camera, what's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding. So if you don't take them in context, you may think that I'm talking about the jury as the community, but I'm actually, in full context, was talking about the community's involvement and support of him in that proceeding and being told to go home. So I think if the court had taken evidence, then we could have fleshed all of this out. My practice is not to try my cases in the press, and I would have probably agreed to some restrictions as necessary, depending on what they were. But the court didn't evaluate any of those things. And of course, the court didn't find out what I was speaking in response to. But I submit to you that there's really nothing in that written statement that should be even prejudicial. Even under the current gag order, his occupation, his family history, all of that is apparently okay to speak about. Public records are okay to speak about, and those are based on public records. So, I mean, just because the prosecutor doesn't like it, that is not a reason, that's not a justification for a gag order.
So if we construed this order narrowly, I realize there it might be somewhat difficult to do, and just treated it as a poorly written order and construed it as most of the provisions have to do. I mean, there's the one about extrajudicial statements of the defendant, but otherwise, for the most part, what we're talking about are public dissemination or public comments about evidence, prospective witnesses, testimony, et cetera. If that was construed narrowly to be limited to statements about that are aimed at basically tainting the jury pool, releasing evidence, commenting on evidence, that kind of thing, does that give you the relief you actually are seeking, or is that not enough? And would that pass? I mean, the other question is whether that pass is relevant test.
It's difficult to answer that in the abstract. This order says things like possible existence of evidence. Like, I don't know what the possible existence of evidence is. You know, if we could define those contours better, then perhaps so. But, you know, some things that are potential evidence or possible evidence should be fair game for the public to learn about, too. So I think we should be narrowing this to prejudicial evidence, not anything that possibly could ever be evidence. And not all of this order addresses even public dissemination. And I'm sort of unclear even what that term encompasses. You know, social media is a big thing. There was lots of comments on social media. If family members have private social media accounts, is that public dissemination?
Does it matter that the state conceded that a Facebook post would be covered by this order?
The state in its briefing suggested so. I'm not sure I agree with that. I think that may not be public dissemination. I've been asked these questions, and I can't give the answer any more clearly than anybody else from reading that order. I want to point out to the court that we do dispute the extent of the media coverage, the undisputed nature. Everything is in dispute here. Yes, there was media coverage. I don't think it was near as extensive as I've seen in many other cases, but we don't know because the court didn't take any evidence, so there's no basis for that statement. There's no basis for the statement that our written statement was the cause for the gag order. Nobody even alleged that in the motion. Nobody found that in the order. So I don't think that that's a fact that the court can rely on. I also want to suggest to the court as to the standard, and by the way, there's no evidence of risk to witnesses. No one has even raised that. That was commented on a moment ago. I don't know where that came from. There's been no allegation of that, no indication of that. But as to the standard, I do not deny that Gentile may provide some general baseline test for trial participants, but it cannot be the only expression of a test because of the limitations that we've discussed previously as to the regulatory nature and the lack of prior restraint. I think the court has to consider the heavy weight of the First Amendment rights that are at issue and honor those. And here, Aaron Spencer's not asking for a gag order. It's his Sixth Amendment right to a fair trial, and that is usually raised by the defendant in cases where the defendant attacks a gag order. We are not doing that here. So there's not a Sixth Amendment right as competing with a First Amendment right, as is discussed. I think Nebraska Press talks about how the founders didn't tell us which one should win the day. But that's not the issue here. The public has a right to a fair trial, sure, but they also have a right to hear my client's speech and to know what's going on in their judicial system. Thank you.
Dismiss the court.